Good afternoon, everybody. I know that we still have a calling in to the webinar, but I know it's 12 and we've got a lot to cover, so I'm going to go ahead and get started. Thank you for joining me for another one of our topical webinars, focusing this time on hiring for the new school year. So we're going to be talking about criminal background check requirements and procedures that have shifted a little bit over the last year to kind of help you with your hiring process for the 2022-2023 school year. So if I haven't had the chance to meet you yet, my name is Emily Tulloch. I'm an associate attorney here at Franczek, and I also have my contact information up on this slide in case anyone has questions after today's webinar. You're more than welcome to reach out to me or any other member attorney of our firm. So let's go ahead and dive right in. The webinar today is going to be broken into two parts. So first, we're going to be reviewing the criminal background check requirements that many of you are already familiar with. So those are laid out in the Illinois School Code. And then we're going to be discussing the Illinois Human Rights Act amendment that went into effect of March last year that prohibits employers from using a conviction record as a basis for employment decisions unless certain factors are met. And we're going to go through those factors and when you're going to have to use that analysis. I also didn't mention at the beginning, if you do have a question during the webinar, please feel free to put it in our Q&A function instead of the chat. It's a little bit easier for me to keep track of, and I will be checking those as best as I can. So as you all know, applicants for employment within a school district or for a school district, except for bus driver applicants, who we're going to talk about in just a little bit, are required to authorize a fingerprint-based criminal background check during that application process. And I know you're all familiar with this, so this will be a little bit of review. But that fingerprint-based criminal background check is really to determine if the applicant has been convicted of any disqualifying enumerated criminal or drug offenses. So when we talk about enumerated criminal or drug offenses, those are offenses that are named within the school code and that that are named within the school code and that prohibit an applicant's employment with the school district. And we're going to be talking about some of those examples in a little bit. We're also checking for if an individual was convicted of a felony within the last 7 years of their application for employment. And then we're also checking for if they were convicted of any other offense in another state that would be charged as a felony in Illinois. So those are the things that the background check is going to come up with and that you're going to be reviewing. I will note here, and I think there's some been some concern about this lately because I've heard from some of you that you're not getting these background check results back quite as quickly as you may have in the past when you're submitting fingerprint-based if you're submitting for criminal background checks with the Illinois State Police and the FBI. So keep in mind that the fingerprint-based criminal background check only has to be initiated prior to employment. It does not require it to be completed before the applicant begins work. Now, you may have different policies and procedures in your board policies or in your practices. So obviously, I would be looking at those to see whether you have a policy of making sure they're completed before employees start. But in terms of the law, they're only required to be initiated. So you can, have some language in your offer letter or, offer package to an employee applicant that really says that the offer is conditioned on results of a criminal background check. And I know a lot of you are already doing that. And so that might alleviate a little bit of that issue when we're talking about getting your checks back a little bit later than you typically would see. I will note that that's a little bit different for student teachers. And we'll talk about student teachers in a minute. But for student teachers, that background check has to be completed before they start. So we'll go over that in a moment too. Now, in addition to those criminal history records checks, those fingerprint-based background checks, a school district is also required to perform a check of the statewide sex offender database and the statewide murderer and violent offender against youth database. And those, as you all know, are quick, internet searches. So those also have to be initiated before an employee applicant begins employment with the school district. And I'll just note too that a recent change in the law also requires school districts to make subsequent checks of these databases every 5 years that the individual remains employed at the school district as well now. So if you have an employee where, 2022-2023 school year is going to be their first school year, and you're doing those background and offender database checks now, if that employee is still with you, 5-6 years down the line, you're going to be having to do these database checks again, not the entire fingerprint-based criminal history records check, but just these checks of the statewide sex offender database and the statewide murderer and violent offender against youth database. So in terms of timelines for criminal background checks and checks of the databases, again, for employee applicants, these checks only need to be initiated prior to employment. The law does not require that they are completed before the applicant begins work. I know that there are some school districts out there, and there's some school districts that we work with that want them to be completed before, just based on, past practices, or, based on, the ability to just make sure that everything is in order before hiring an employee applicant. So again, make sure you're checking your policies for that. And then in the case of student teachers, like we talked about a little bit earlier, the database check and the criminal history records check not only have to be initiated, but they have to be completed prior to the start of any student teaching. So just keep that in mind for when you're timing these out. Okay, really quick, I wanted to touch on some other groups. So first is vendors. So any vendor that has a contract with the school district that has direct daily contact with students is also subject to these criminal background check requirements. So, we really recommend that you're including provisions in your agreements with vendors that require them to make their employees available for the district to conduct background checks pursuant to school code requirements if they're going to be sent to the school district as part of the agreement. I would also recommend language stating that, the vendor agrees that they're not going to send any employee to the school district that, would be subject to license suspension or revocation pursuant to the school code. And of course, we're always here to help with some of that contractual language as you're working through those negotiations with vendors. But I do think that that's an important requirement to be aware of. And then bus drivers are a little bit different. So the school code specifically exempts school bus driver applicants from the criminal background check requirement. And that's because school bus driver permit applicants have to complete an application that's required by the Secretary of State and then submit the completed application to their prospective or current employer, along with fingerprints for the FBI criminal history records check. So that might be you if you're directly employing school bus drivers, or that might be a vendor who you're working with who employs school bus drivers, that you're working with through the vendor. For bus drivers, the results of the Illinois State Police check are returned to the driver's employer, whether that's you or whether that's a vendor. But that FBI check is continuous for these individuals. So it's not returned to the employer. It continues checking on, a regular basis. So that means that if any offense that might disqualify a bus driver pops up in that continuing check through the FBI, it's going to notify, the individual that either the vendor or the employer who requested that check. So you're going to know, if there's any convictions based on the FBI pretty quickly. And then you can have contractual provisions for this too, stating that criminal background check requirements have to be satisfied and verifying that bus drivers, that would be prohibited from having a school bus driver permit shouldn't be assigned to the district. I'm seeing here a couple of questions too. So I have one on, whether the background check for vendors needs to be done by the school district or whether it can be done by the vendor. So this is a really great question. background checks, pursuant to the school code, it states that the school code that the district itself will be responsible essentially for doing these checks, including those on vendors. This is a point where I would really recommend, if you're having an issue here, or if you're having some pushback from vendors, to really reach out to your counsel, whether it's us or someone else, just to walk through what the requirements are. I think we've seen a lot of questions in this area because there are some vendors who do their own criminal background checks, but they typically are not of the level that school districts are required to do. And that's because school districts are essentially, by statute, we're allowed to get these FBI criminal background check reports back, and a lot of vendors aren't able to get those same reports to the same level that school districts are. So I would really be recommending that you're performing those checks. And of course, if you're working with vendors, think about having provisions in those agreements that say that they're going to make those people available to you, potentially having provisions in an agreement that state that maybe they're responsible for the cost. But I would recommend that you're checking in with counsel and thinking about doing those checks on your end. And then we also have a question about whether outside vendors are going to need that 5-year sex offender or violent murderer checks. So again, that's a fairly new requirement. I would recommend doing those, 5-year checks if you're at all, able to do those. They're quick, they don't take a whole ton of time. And I think that's your best bet in terms of complying with the new law. Okay, so once an applicant submits to fingerprint-based background check, their information is provided to the Illinois State Police and the FBI, and the FBI and the Illinois State Police then issue the criminal history results. So you'd be getting 2 documents back, right? The FBI criminal background report, and that's going to include arrests and convictions for the applicant anywhere in the United States. The Illinois State Police background report is only going to list those offenses that occurred in Illinois, and only those for which an individual was convicted. So arrests that don't result in convictions are not going to appear on your Illinois State Police report. And that's helpful because if your FBI report has, a whole laundry list of charges, you can kind of compare between the 2 to see where convictions actually occurred and get a little bit more information on those. Okay. So after performing these checks and receiving the results, you as school officials are going to have to determine whether the individual can be employed by the school district or not. An applicant cannot be employed by the school district if they satisfy any of the requirements you see up here on this slide. So if they've been convicted of an offense that subjects them to license suspension or revocation under that section of the school code, they cannot be employed. And I think this is where you're going to see a lot of prohibitions on employment. So some examples might include, certain offenses under the Cannabis Control Act, offenses of the Controlled Substances Act, most sex offenses, and what we call Class X felonies, armed robbery, aggravated battery with a firearm, aggravated arson, those types of offenses, among, a laundry list of others. Here's again where if you're not sure, I would recommend reaching out to counsel and just making sure we're double checking, whether there's any prohibition on their employment with the district based on the offenses or the convictions that are listed in their criminal history report. I'll also just note here that, under this prohibition, there is an exception for certain offenses. So, for example, certain offenses under the Cannabis Control Act. So, maybe an individual possesses a small amount of marijuana and they were convicted of that, but they're ordered probation. and they complete their probation satisfactorily. So in that case, they would no longer be prohibited from employment with the school district. And this is based on several factors. The fact that they, finished their they satisfactorily completed their probation, and the fact that it was, a lower level amount. So just be aware that there might be some caveats and some exceptions based on probation. I'd also like to flag for you here, and I think we get a lot of questions about this. We talked about earlier that there's the school code requires you to determine through these background checks, whether an applicant has been convicted of any felony within the last 7 years, even if they're, beyond those enumerated offenses that are listed in the school code. So, right, it allows us to review any felony conviction within the last 7 years, even if it's not an enumerated offense. But that doesn't mean that any felony conviction within the last 7 years necessarily prohibits employment with the school district. So let me give you an example of that. If an applicant is applying for the 22-23 school year and their record reveals one conviction for assault, assault is not an enumerated offense, and say that conviction happened in 2018. So the district can consider that conviction when making their employment decision, but it does not prohibit the applicant from employment at the district. So that wouldn't automatically prohibit their employment, but it can be considered. And we're going to talk about next, the process for considering these additional, non-prohibited, non-enumerated convictions, and the new process under the Illinois Human Rights Act that we're required to follow. But I just wanted to flag that because I think a lot of, we've heard a lot of schools, getting confused about that 7-year requirement. I'll also note that an applicant is prohibited from employment at the district if they are registered on either the statewide murderer and violent offender against youth database or the statewide sex offender database, or if they're a perpetrator of sexual or physical abuse of a minor pursuant to Juvenile Court Act proceedings. So we mentioned on the last slide how you might consider non-enumerated convictions that appear in an individual's background check. And we're going to walk through the process required to do so now, which is really a change in the law over the last year and a half. And you might have had to do this within the last school year, but many of you may have not had to work through this process yet. So we're just going to go step by step into what the new law requires and how you satisfy it. So as we talked about earlier, the Illinois Human Rights Act was amended in March 2021, and it really limits an employer's ability to consider an applicant or an employee's criminal history. So the Illinois Human Rights Act amendment applies to all Illinois employers with at least one employee, and that includes public and private employers. We're going to be focusing solely on how this affects school districts today during this webinar, but I did want to point that out. So on this slide, you'll really see some of the key language in the amendment regarding employee applicants. So it says, unless otherwise required by law, an employer can no longer disqualify or take adverse action against an applicant or employee with a conviction record without first determining whether there's a substantial relationship between the conviction and the job or an unreasonable risk in employing the individual in the particular job. So let's break that down a little bit. The unless otherwise required by law language, let's talk about that first. So employers cannot disqualify a job applicant with a conviction without going through an analysis unless otherwise required by law. I think that piece is really important here for school districts in particular, because as we just talked about, the school code does specifically prohibit applicants with certain convictions from employment. Therefore, if an applicant has an enumerated conviction that would prohibit them from employment at this school district, so again, things like, a conviction under the Controlled Substances Act, a conviction of a Class X felony, a sex offense that's enumerated in the school code, then you are not going to need to go through any additional interactive process required under the Illinois Human Rights Act that we're going to talk about, okay? So there's kind of two lanes that you can go in. If they do have any conviction of an enumerated offense, then they're prohibited from employment. We don't have to do any further analysis. The second road is they have convictions of non-enumerated offenses. that we want to consider in making our employment decision, then we have to go through this analysis that we're going to talk about now. And I'm going to be using the term interactive process a lot, and so we're going to break down what that means. And that's really the piece where we're talking about an employer being required to determine that there's a substantial relationship between the conviction and the job, or an unreasonable risk in employing the individual in a particular job. So let's walk through each requirement individually. So to determine whether there's a substantial relationship, we have to consider whether the position offers the opportunity for the employee to engage in the same or similar conduct, and whether the circumstances leading to the conviction will reoccur if the individual is hired in that position. So basically, a substantial relationship might be found where there's an opportunity for the employee to engage in the same conduct if they're hired in that certain position. In the alternative, the district might consider if there's an unreasonable risk in employing the individual in the particular position. So to determine whether there might be an unreasonable risk, consider whether the risk the employee poses in the workplace would be unreasonable under the circumstances. And for a lot of these, you might be thinking of, certain violent offenses, certain, offenses that might involve dishonesty or fraud if they're working in the internal office. Those kinds of things are what you want to be thinking about. And there's certain factors that have to be considered when making that substantial relationship or unreasonable risk determination. So I have them up here, but we have to think about how long ago was their conviction, how many convictions appear on their record overall, what's the nature and severity of the conviction or convictions, how does it relate to the safety and security of others? What are the facts and circumstances surrounding the conviction? How old the individual was when they were convicted, and if there's evidence of rehabilitation efforts. I will note too, when we're talking about how old the individual was when they were convicted, juvenile records can't be considered. So, if they were, and are often sealed, but if that does appear on their criminal history check, those can't be considered. And then after considering all of these factors listed out in the slide here, you as the employer are going to have to make first a preliminary decision as to whether the individual's conviction record disqualifies them from employment. And if you do decide that, if you do make that preliminary decision that their record disqualifies them from employment, then you have to notify the employee applicant in writing of your decision and the reasoning behind it. So the notice has to document and contain information regarding, which convictions are the basis of your decision, your reasoning for the disqualification, a copy of the conviction history report, and an explanation of the applicant's right to respond to the notice of your preliminary decision before that decision becomes final. So that's a right for the employee or applicant to provide evidence, challenging the accuracy of the conviction record you received, or mitigating evidence, such as rehabilitation. They might talk about how long it's been since the conviction, that sort of thing. So the district has to provide a school district has to provide the applicant at least 5 business days to give the district its response before it makes a final decision. And the law does require that prior to making that final determination, the district consider any information that's submitted by the individual. If after we've gone through that process, so say that you've decided that the conviction record doesn't have any enumerated offenses, but it does have some offenses that are giving you pause, and you've gone through this interactive process and you've issued the preliminary notice to the applicant, they've provided you with a response and you've now considered that response. Let's say that you still want to disqualify them from employment with the school district. So if your final determination is to not hire the applicant based on their conviction record, then you have to send one final notice to the applicant in writing, and that notice has to include identification of the disqualifying convictions that are the basis for your decision, the reasoning for the employee applicant's disqualification, any existing procedures that you as a district might have for the individual to challenge the decision or request any reconsideration, and then notice of their right to file a charge with the Illinois Department of Human Rights. So some action items, when you are complying with this new law, that I would recommend, doing now. So provide training on the required analysis and interactive assessment process. I know a lot of you, are on this webinar today kind of for that training. So, we would recommend the individuals who are doing your hiring decisions that they're aware of this process and the requirements. And then I'd also recommend developing a written notice template to send to applicants or employees who are preliminarily disqualified based on their criminal record, and then for those who are disqualified as a final notice. So both your preliminary written notice and then your final decision notice. And of course, we're always here to help you create those templates as well. I'll just run over as well. There's, a quick note on potential consequences for failure to go through this interactive process when it's required. So employers may have to respond to charges through the Illinois Department of Human Rights, and they may be found liable for a violation of the Illinois Human Rights Act if it's determined that this process wasn't followed and an employee or an applicant was unfairly, disqualified from employment at the district based on consideration of non-prohibited offenses on their conviction record. You also may be subject to damages and attorney's fees. Those are just some of the consequences that the new amendment contemplates. And we have a couple questions that I want to answer before the end of our time here. I know we got a few in. Okay, so what about volunteers? Are they required to be fingerprinted? So the Illinois School Code does not require that volunteers are fingerprinted. I think this is really going to depend on what you're using the volunteer for and what the supervision is. So I think there's a little bit of a gray area when we talk about that direct daily contact with students where vendors are also required. I would consider that analysis here too and think about, are these individuals having direct daily contact with students? Is this a one-time thing or are they coming back on a weekly basis? Maybe they're just a field trip chaperone, but are they going to have unsupervised access to students? I would be thinking about those things. If you're going to have a teacher in the room with them or in the same place with them or a school employee that's with that volunteer at all times, I'm a little bit less concerned about whether they're fingerprinted or not. I think you have to think about, the activity itself, the amount of contact with students and whether there's going to be that supervision. And then we also got a question about, whether those FBI background checks are nationwide, and talking about how there's some states that may not report to the FBI. I believe that's true. You're going to get back a check that is as comprehensive as you can possibly get. So what I would do is with your FBI checks, I would be making sure that you're checking for any offenses that were charged in Illinois and any offenses that were charged in other states that might count as one of those enumerated offenses in Illinois. We're doing the best we can to review those, based on the information you have. But, if it doesn't pick up on states that don't report, that's just, we can't, prohibit an employee based on, offenses that we're not aware of. I got a couple more questions here. So again, what about work-based learning experiences? So if a student is assigned to, say an externship opportunity or work-based learning experience with a local business, we've in contracts, I assume that you probably have a contract with that business. I think our practice has been, if they're going to be having direct daily contact with the supervisor or someone, we would really recommend that individual have a criminal background check pursuant to the school code. I think that sets up you all the best in terms of liability. So that's typically what we recommend in those areas. I do think, that's a place to talk with your counsel about if you get a lot of pushback. That is all of our time today. I know we have a couple other questions. I will try to follow up with those individuals afterwards, but if you have any additional questions, please feel free to reach out to me or any attorney at Franczek that you work with if you have any questions about the criminal background check process and hiring for your new school year. Thank you again, and don't forget to tune in to our next webinar on August 8th when several of my colleagues are going to be discussing updates on COVID guidance for the new school year. Thank you.